Can a nursing home take your house if it is in a trust in New York? Long-term care is a growing concern for many New York residents, especially as nursing home expenses continue to climb. The possibility of losing your house to pay for care is a fear shared by many families. For those thinking ahead, placing a home in a trust can offer a strategic layer of protection. But not all trusts offer the same safeguards, and timing is everything. Under New York law, a nursing home cannot take your house if it is in an irrevocable trust, but this is only true if the trust was created and funded at least 5 years prior to applying for Medicaid. In contrast, a revocable trust will not protect your house from nursing home claims because the assets are still considered part of your estate. The legal framework around trusts and nursing home claims. Irrevocable trusts are key when it comes to shielding property. Once you transfer your home into this type of trust, it is no longer counted as part of your personal estate. Medicaid, not the nursing home directly, determines eligibility and reviews asset transfers during the 5-year look-back period. If the transfer occurred within that period, the protection could be voided and your home may become vulnerable. Nursing homes themselves do not challenge trusts. However, Medicaid agencies can examine the trust structure and timing to assess eligibility. If Medicaid suspects a trust was created to hide assets, it can result in penalties or denial of coverage. A New York law firm with experience in elder law can help you understand these legal nuances and protect your estate accordingly. Planning early with guidance from a lawyer is crucial in maintaining eligibility and shielding your assets. Answering the question, can a nursing home take your house if it's in a trust? The answer depends on 2 critical factors: the type of trust and when it was established. If your home is placed in a revocable trust, it's not protected. Medicaid will still count it as part of your estate, and the nursing home can claim it to recover costs. On the other hand, an irrevocable trust offers real protection, but only if it's been in place for at least 5 years before applying for Medicaid. Even then, this protection is not guaranteed without proper structure and compliance. The home must truly be removed from your control, and Medicaid must view the transfer as legitimate. An experienced attorney is essential for ensuring that the trust is set up properly and in full compliance with New York's Medicaid rules. Understanding the process. How trusts work in this context: an irrevocable trust effectively removes your ownership rights. Once the home is transferred into the trust, it belongs to the trust, not to you. You may still live in the home or collect rental income, but you can't sell or refinance it without the trustee's approval. This setup prevents the home from being considered part of your estate, which protects it from Medicaid estate recovery after death. The most common type used in these cases is the Medicaid Asset Protection Trust, MAPT. To work, an MAPT must be funded at least 5 years before applying for Medicaid benefits. This ensures the property will not be counted and thus protected from claim. A revocable trust, in contrast, allows full control. That control means Medicaid sees the house as available, and it won't protect you. Revocable trusts are useful for avoiding probate and managing assets during life, but they are ineffective for nursing home protection. In every case, early action and legal support make the difference. A law firm familiar with New York's trust laws can guide families in choosing the best structure and preparing for the future. To discuss your options or start planning, contact Schlessel Law PLLC at 516-574-9630 or visit us at 34 Willis Avenue, Suite 300, Mineola, New York, 11501, United States.